And welcome back to the Law&Crime Network. I'm your host, Amy Dash, and I'm here with Jessica Ramirez. She is a criminal defense attorney out of Newark, and we were watching some testimony from an officer, a highway patrol officer, out of this trial in San Diego, where a former Marine is on trial, and he's charged with the second-degree murder of 2 medical students, along with some other charges related to the injuries sustained by 3 other medical students that were in the car. He was driving down the highway the wrong way after drinking a lot of alcohol at a local bar in San Diego, and this occurred around 1:30 in the morning. So you and I were talking because they had just played the audio of this former Marine when he's in the hospital about an hour and a half after the accident takes place, and he's clearly still drunk because his blood alcohol level had come back nearly double the legal limit an hour and a half after the accident. So imagine, Jessica, how drunk he was during and prior to the accident, just prior. So the question that's come up is, how could he be read his Miranda rights and be interviewed by police at the hospital when he's still so drunk?
Well, I think, it's definitely policy. So they have to, the police, they have to read the Miranda rights when somebody's being interrogated. Is it good policy when someone's under the influence? No, I don't think it's a good idea, but it's definitely policy nonetheless, and you have to follow it. And I think that it's going to be up to a defense attorney to then argue to the judge that their client was so intoxicated that whatever they said has to be thrown out. But should it be done? Absolutely. It's if you're being interrogated, that's part of our law.
Well, I was saying to you, a lot of times, if you're drunk, you're not as good as a liar. Like, you can lie more easily when you're of sound mind, and that's really the legal test. Is this person of sound mind? Are they able to understand the rights being read to them? Are they able to answer intelligently and respond accurately to some of the questions that are being asked to them? And you can see that he does answer a lot of these questions. So I guess the issue that would come up would be if he responds to something and it's just so out there, like they say, where were you drinking? And he says, oh, well, I happened to be on Mars and I was having a little alcoholic beverage up there in space. Then obviously that would be contested as, hey, wait, this shouldn't be admitted because this is just so outside of the realm of what would be an accurate response. But that wouldn't really negate his other responses that would be accurate.
Well, I think then it comes down to, again, how drunk was this person? Was he blacking out? Did he remember the answers? Mm-hmm. Again, you have to convince the judge. He was so drunk that everything should be thrown out. We can't piecemeal, well, he said this correctly, but then he didn't say this correctly. I think that it's going to be an argument that the defense has to make in order to get it thrown out or not.
But on the flip side of that, I guess the opposite argument would be, well, listen, this guy was interviewed right after this happened. So we wanted to find out from him what happened while it was still fresh in his memory. Therefore, if he answered anything accurately, such as the name of the bar where he drank, that enabled us to go over there while potentially people were still there and their memories were fresh and gather our information.
Well, I mean, what is fresh memory when you're so intoxicated? I mean, because he remembered the name of the bar? Okay. I mean, again, you have to make that argument. We should make that argument as defense attorneys that they were so, our client was so drunk, everything should be thrown out. You can't piecemeal things.
Yeah.
I guess it gets very difficult.
But when people are saying whether the Miranda rights should be read at all to somebody who's drunk, whether somebody should be interviewed at all, there is an argument to be made that if the police want to do their investigation then and there, they need to start gathering information so they can get straight to the scene or straight to where he was before and gather information there before it potentially goes missing or gets tampered with.
I think it should be read because that is the policy, that is the law. They're being interrogated. Once you're going to be interrogated, you have to be read your Miranda rights.
Yeah.
God forbid they didn't. So it should be done, absolutely. Again, is it good policy? I don't believe so. But then again, it's going to be our job to then argue that everything should be thrown out because our client was so intoxicated. But should it be done? I think so,
because you're hearing them on the audio saying, you know, you're drunk. Is the room spinning? Do you feel drunk? And he's saying, yeah. I mean, clearly it's hard for him to remember things and to answer accurately. But they are able to get things out of him. For instance, they start giving him, it was like a multiple choice questionnaire. When they're trying to figure out where he was drinking beforehand, they just start listing off bars that are in the area. And eventually he is able to confirm where he was actually drinking.
That's why I think it's great that this is being shown to the jury, because again, I always go back to what a great system we have. It is a jury of our peers. They're going to look at this. It's common sense. What do they believe? What don't they believe? Is he being fed things? Is the guy really making conscious answers? And it's going to be up to them. But absolutely, I think that the Miranda rights should be read. Again, it goes, do I think it's a good idea? No, it's not a good idea, but it is the law and you should follow it.
Yeah, and I want to switch over and talk about plea deals, which we were talking about before the break. So he was offered plea deals. He was offered either to plead guilty to second-degree murder and get 15 years to life, so he would be eligible for parole at 15 years, plus 8 years behind bars. Or he could plead guilty to gross vehicular manslaughter while intoxicated and attempted murder with a sentence of more than 25 years in prison. You were saying those aren't deals at all.
Yeah, I mean, again,
based on your experience.
Based on my experience, once you start mouthing off numbers like that, that's really not a plea deal.
Why? Because they're so high?
Because they're so high, and your client's going to say, I'm going to take my chances. And then when you start talking to your client about taking a plea and doing a factual basis and having to admit, yes, my intent, and with a murder charge, you have to say, my intention was to murder that person. My intention was to kill that person. That gets very difficult. And if that wasn't your intention, it's going to be very difficult for my client to have to admit that. And again, when you're throwing off high numbers like that, a lot of people are gonna, that's not a plea deal. Let me take it to trial and take my chances.
And just to be clear, he's not contesting his involvement in this crime. What he's contesting is the murder charge element. But you and I were disagreeing a little bit on that, because I said, listen, the intent is there the second this guy gets in the car. When you're that drunk, you get in the car. This is not a second grader. He knows at his age that somebody could potentially be killed if he's drunk driving. And you were saying, well, maybe his state of mind wasn't capable of comprehending that.
Absolutely. And again, when you look at the murder charge, or when you look at a murder charge, you have to really concentrate on the defendant's state of mind. What was his intention? What was his decision? What was his plan? Did he plan to get into this car to kill somebody? No, he was drunk. He was very drunk. And I feel for the victims. It's very sad. He is going to pay for his crime. He is going to go to jail. Absolutely. But for a murder charge, was that his intention? Was that his state of mind? Did he purposely want to kill these people? No, I don't believe so. I don't believe that was his intent. And I believe that when you're so drunk, you can't really form an intent. So is it murder? No.
But then you would face a lot of arguments from the people who are very high on a personal responsibility element here. The second that you make a conscious choice to go drinking, you shouldn't even bring the keys to your car with you, that you should have somebody there. You're going to go drinking at a bar. It should be out of the realm of possibility that you're going to get in your car. And what I was saying to you is, listen, we have very sympathetic victims here. We have 5 medical students, young kids, who were going to be productive members of society with their whole lives ahead of them. 2 of them are dead. 3 of them sustained such serious injuries. That we saw in the pretrial hearing, this poor young male medical student up on the stand, he literally had plates and screws encompassing his entire head and neck. Some of them miraculously going back to medical school to still try to benefit society. But these were the young kids that wanted to help people. Meanwhile, 2 of them are dead. And what was this guy's purpose that night? I mean, to drink himself into a stupor? So how is it justified to say that he shouldn't get life when he took 2 lives?
Absolutely. The victims here are, it's so sad. It definitely pulls on your heartstrings. But we can't look at the victims. That's not the legal standard. We don't look at the victims and what they would have accomplished in life. I mean, then
We
if
do
you
it
that,
in sentencing hearings.
well, yes, in sentencing purposes, yes. But whether they're going to be found, this person's going to be found guilty or not, we can't do that. If that was the case, I mean, there's children. I mean, they're really when you look at children, if that's the victim that you're looking at.
Yeah.
So absolutely, I mean, it is very sad, but that's not the legal standard here. The legal standard, was it murder? Was it deliberate? Was that his intention? And that's really what we need to be looking at, thankfully.
But that's not usually how it happens in practice, is it? I mean, you have jurors there. We've seen in child murder cases where there's just been circumstantial evidence and there have been convictions because of the nature of the victim. I mean, obviously with the Casey Anthony case and some other cases, we've seen acquittals because she had just an excellent attorney who was able to grandstand and basically convince jurors about things with zero evidence. But in most cases, the jury does take into account the victims, especially when the prosecutors are putting these people up on the stand and showing how maimed they are from this horrible accident.
Absolutely, the jury does take into account. That's reality. That's life. But then there is the jury process, and they get the rules of the jury, and they know they shouldn't be looking at the victim and what the victim could have accomplished. Is it part of life? Absolutely. But I tend to find that jurors really take their job very seriously. They really look at the jury deliberations. They look at the rules. They look at what they're supposed to do, and they really take it very seriously.
Yeah.
So, I mean,
though with the jury selection process, a lot of times prosecutors are getting people on that jury that would be more sympathetic to accident victims.
Absolutely.
I mean, the defense can't veto everybody, right?
That's true, for sure.
So it will come into it, I think, in the end. In terms of whether he gets manslaughter or convicted on the murder charge, when you say let's look at the legal standard, it seems that the legal standard for second-degree murder doesn't require malice aforethought. It only requires that there be a killing in the course of committing an unlawful act. Here, he's drunk driving. So what's the problem here? How would you argue against that?
I think that, again, you got to look at his intention. I think that when I look at the second-degree murder charge, it does go into the mindset of the defendant, and that wasn't his mindset, that wasn't his intention, that wasn't his thought process. Did he deliberately choose to commit this murder? I don't think that's the case. So again, I think the murder is really very severe. I think that justice can be served with a manslaughter charge. He is going to pay for his crime. He's going to be thinking about this for the rest of his life. This guy was a Marine too. He did fight for our country. They talked about where he was from, that in the state that he was from,
Oklahoma,
or I'm not really sure.
In Indiana, he spent some time in Indiana.
And DUIs are not a big thing. I mean, we talked about that as well.
Uncommon, yeah.
That us in the East Coast, that is a very bad thing. I practice a lot of immigration law, and I have to tell my clients sometimes when they get caught with a DUI, I have to tell them, listen, I know in our countries it's really not looked at as a severe thing. Just like back in the day, you could smoke while you were pregnant. So when you look at that, and again, our defense, we have to make our clients look normal or human. We have to talk about who they are, and that is who he is. Again, is he going to pay for his crime? Yes. Is he going to go to prison? Yes. Is it a manslaughter charge? Yes. Is he contesting? He's not contesting he didn't do it. He did do it.
Right, but part of the defense, as you were alluding to, is that his attorney is saying, listen, he didn't have any background knowledge as to the dangers of drunk driving, or he wasn't properly educated. I just think that's garbage. I think it's common sense that if somebody is drunk and they get in the car, even if they're not as drunk as he was, there's a possibility that you could kill somebody. You just should not get in the car. But we were talking about the differences in different states. Like in Louisiana, there's a law that you can open a beer can and have a beer while you're driving. And in New Orleans.
And that's us educated women, people.
But isn't it common sense?
No, it really isn't. I know because I practice this all the time, especially with people from different countries. It's not common sense because it's not looked at. Again, we got to go back to how it was here in the 50s and the 60s, and things have changed. Even with domestic violence laws, I mean, things have changed, and now driving while intoxicated is a huge thing in the United States. Thankfully so. I'm not,
But with all the pop culture, the movies, I mean, even you gave a good example, domestic violence. I feel like your argument, and tension's good on this network, so I'm not attacking you personally, but it's like saying to me, with domestic violence, well, a man punching a woman in the face, how is he supposed to understand that that's going to harm her if he hasn't been properly educated on the repercussions of beating somebody senseless? I mean, that's what it sounds like to say that somebody doesn't know that getting in the car and driving drunk could kill people.
Well, he's looking at 30 years in prison. I mean, that's a big difference here.
30 to life.
30 to life.
Yeah.
I mean, that's a huge, huge deal. It's taking somebody's liberty away for that long.
For taking 2 lives, though, some people would argue, eye for an eye.
Right, but he had to have that intention that he was going to do that, and I don't think that was his intention. I don't think that was the case, and I think they're going to have a hard time, the prosecution, proving that.
Also, to pick up on one of your points, something did come out of this, a law that said that bartenders need to be educated on when to stop serving people drinks and also potentially when to call the police if they see somebody getting in the car. There were a lot of people that did not take action when they clearly saw that he could be a danger. Do you think that that's a responsibility that should carry a criminal penalty? This law just says that bartenders have to take mandatory courses. But what if a bartender, for example, I was out this past New Year's Eve at a bar, a man came in. It was actually, we were in the back at a restaurant, but in the front at the bar, as we were leaving, the door was wide open. A man had vomited everywhere. I mean, he came in, he ordered like 3 drinks, heavy drinks, and he was given them. And even my husband said, I saw the way this guy came in. The bartender should have known not to even give him a drink. That's a responsibility of a bartender. What do you think about passing criminal liability on to bartenders, hypothetically?
Hypothetically, I think that's a tough one too. I think that's a lot of responsibility. They're bartending, they're working, they have to be, serving drinks, taking care of the bar, and also have to look at people and see whether they think that they should be stopped or flagged. Mm-hmm. And if I'm not doing that, am I going to be criminally liable? I think that's a bit much as well. Maybe a fine, absolutely, but criminally liable, that's a lot.
I don't know if you ever saw the final episode of Seinfeld, but it's a lot like the Good Samaritan law, where all of a sudden, like the main characters in Seinfeld in the final episode are put in jail because they're not good Samaritans. They don't take those actions to try to stop somebody from doing something that could potentially harm the public. So it's controversial.
I didn't watch the last episode of Seinfeld.
How could you?
But I think when you're going to have a criminal record, your liberty is going to be taken away because you're not being a good Samaritan. That's tough. I don't think that's
But the law does allow for that in some circumstances. For example, if you have a pre-existing duty, like let's say you're a physician and somebody's in front of you dying, you do have an obligation to take some acts to try to assist the person. Or if you're a police officer, things like that. So I guess this would be taking it one step further.
I think so, but a bartender, when they're, they're crazy in the bar and busy and having to take care of the bar and the drinks and bringing people up and also be criminally liable because of somebody's drinking, I think it's a bit much.
I mean, this is a crazy proposition, but what about, we have these machines where people have to take tests, breathalyzer tests, and it shows their level of alcohol in their system. What about having that at bars? Somebody leaves the bar, they have to blow into some sort of mechanism before they take their keys. So for example, the bar, just like in a valet system, is collecting keys. You can't get your keys if you breathe a certain level of alcohol. Only a designated driver could.
That's an interesting proposition. I don't know how it's going to work.
How many lives would that save?
I'm sure a lot, but how is it going to work? My goodness.
Same way you drop off your keys at a valet if you go to a fancy wedding or something like that, and then you just have that breathalyzer, and you're going to have a bouncer at the bar anyway. So that's another responsibility, that as you're leaving, you have to breathe in and he has to check your level.
I don't know.
Interesting, right?
Interesting.
If any legislators are listening, credit, you can call it Amy's Law. But how about these people that are on the stand? You said that having these victims on the stand, showing how impacted their lives have been from this terrible accident, should not factor into the jury's analysis. But how powerful do you think that testimony will be in practice? And even if the jurors follow the law, will it affect the outcome at all?
Absolutely, it's going to affect them. You can't help it. I mean, you're seeing them in real life. You're seeing how impacted they are, what their daily lives. It's very sad. Do you have to do that? Are they going to do that? Absolutely.
Okay, and we are back in court, so let's head to the courtroom for this murder trial out of San Diego.